Motion to dismiss my criminal case. Everybody wants their criminal case dismissed, and I understand why. No one wants to be charged with a crime, but a straight up dismissal after filing a motion to dismiss is not very common in a criminal case. And it's not because we don't want the case dismissed. I would love it if every single one of my clients' cases were dismissed. But my wants and desires don't change the reality that most cases are not appropriate to file a motion to dismiss. Why? Well, there are a couple of reasons. Number one, the amount of evidence required to charge a person with a crime is called probable cause, and it is not a lot of evidence. It's not the beyond a reasonable doubt necessary for a criminal conviction. It's not the clear and convincing evidence necessary to take your kids from you, and it's not the preponderance of evidence, the more likely true than not necessary to win a civil lawsuit and win money. The standard of proof to charge a person with a crime is probable cause. Courts have said probable cause exists when the facts and circumstances under an officer's knowledge, which are reasonably trustworthy, warrant a man of reasonable caution to believe an offense has been or is being committed. That's a super fancy way of saying that there is a reasonable ground for belief of guilt. Now your next question might be, reasonable to who? The who question is the second reason why dismissals are not too common. When a person is arrested, an officer writes a police report called a probable cause affidavit, listing why they think there was probable cause to arrest someone. The probable cause affidavit then has to be submitted to a prosecutor. The prosecutor then has to review that probable cause and say, yeah, there's probable cause. They sign off on it, and the prosecutor gives that probable cause to a judge. A judge then reviews the probable cause affidavit, and only if the judge finds that there is probable cause are criminal charges filed. So to get to the place where a person is facing criminal charges, a police officer, a prosecutor, and a judge have all reviewed the probable cause affidavit and have determined there is probable cause and criminal charges are appropriate. The nature of how criminal charges come about makes it extremely difficult to win a motion to dismiss. Now, there is a statute that lays out how to get charges dismissed. Indiana Code 353414 lists 11 ways a person accused of a crime can file to have their charges dismissed. But these are super specific reasons and not at all common in criminal cases. In reality, a straight dismissal of criminal charges is very limited and rare. In my experience, if we can show a traffic stop was illegal, then we can typically suppress all the evidence after that traffic stop, which will lead often to a dismissal. In a case with guns, drugs, or other objects, if we can show the evidence was illegally or improperly obtained, we can exclude that evidence, oftentimes leading to dismissal. If we can show the state took too long to bring charges or move forward on charges, we can seek to dismiss based on Criminal Rule 4, which states cases must be brought within a certain time frame. Sometimes witnesses change their story or turn out not to be as helpful as the prosecutor would hope. This can sometimes lead to dismissal, but oftentimes not until the absolute last minute. Filing a motion to dismiss by law is appropriate only in very specific circumstances. It's been my experience that when a client tells me they want to have their case dismissed, what they really mean is the prosecutor is using bad witnesses. The witnesses were on illegal substances or drinking, or they just don't like me. Sometimes my client even have proof the witnesses don't like them. Or the second reason, Mark, this is just a big misunderstanding. If we just talk to the prosecutor or judge, they'll dismiss the case. Or, hey, Mark, the evidence is weak because there's not a lot of it, or it's all circumstantial. Well, in Indiana, bad witnesses are not a reason for filing a motion to dismiss. And if we tell the prosecutor their witnesses stink, the state can simply try to make them better or find more witnesses. A misunderstanding is not grounds for filing a motion to dismiss either. And by talking to a prosecutor, you simply give them more evidence to find a crime to convict you of or to use your words against you. Never talk to a prosecutor. And weak evidence? Well, guess what? It's going to come in. Why? Because Indiana has a specific rule that if the evidence is relevant, it comes in even if it's weak. The rules of evidence state evidence is relevant if it has any tendency to make a fact more or less probable than it would be without the evidence, and the fact is of consequence to determining the action. The rules of evidence also state that relevant evidence is admissible, and that means even if it's weak. So almost any evidence is going to come in so long as it can help prove or disprove a fact in a case. Now, I'm not all doom and gloom. I'm a positive person. Look at this smile. Even though a criminal case is not likely to be dismissed by the filing of a motion, it doesn't mean you don't fight back against the charges. You gather evidence and be prepared to show the judge or jury, the witnesses are bad and not trustworthy enough to convict the person. You show that no crime was intended, and you attack the elements of the charging information, and you demonstrate to the jury the evidence is weak. Basically, you prepare for a trial. And when you prepare for a trial, I have found something magical happens. The prosecutors tend to get much more reasonable when they realize it's going to be a fight. And here at the Marc Lopez Law Firm, we fight to win. If you have any questions, give us a call at 317-632-3642. We love to talk about criminal cases, and we will talk about criminal defense all day. But most importantly, remember, always plead the fifth.